Getting to know law is like getting to know the universe. It's ever expansive, it's complex, but it's really fascinating. We rely fundamentally on the moral foundations of a community without really need laws for most of the things that we do. But of course, we do need to set out a demarcation of what is right and wrong. In this episode, we'll be talking over about natural law and positive law. But how do they differ? Positive law connotes statutes, law that has been enacted by a duly authorized legislature. So there are two schools of thoughts. Positivist, the law is whatever is on the books. Realist, the law is whatever is actually enforced. But unlike positive law, natural law is not created by human beings. Rather, natural law is thought to be the pre-existing law of nature, which human beings can discover through their capacity for rational analysis. But despite of their differences, how are they similar from each other? Of course, both positive law and natural law, they recognize the existence of law as a social institution that governs human behavior.
I've realized that my use of the law is nothing more than planting a seed. My Manila Bay case took 10 years to even get a simple decision to say government should clean up Manila Bay. Is it clean? Is it still dirty? Maybe it is, but maybe they're doing a little bit something. And in this children's case, for example, I wanted logging in the Philippines to be banned all throughout. I mean, that's a pretty silly thing to ask. I mean, if you ask any lawyer, they will scratch, which I did, they scratch their heads and say, no, you cannot do that. Why children? Why did some crazy lawyer think about naming children as the plaintiff? There were only 800,000 hectares left of virgin forest, old growth forest left in the Philippines. Logging was only being done in virgin forest, a throwback from the old days when there were so many virgin forests. And the government data showed itself that we were cutting them down, as in wiping them out, at the rate of 120,000 hectares per year. My son, my eldest son, was only 3 years old then. When he gets to be 10, there's not going to be anything left. And how can we do this? Is this the kind of world that my kids are going to see? I want to tell the story that these kids have the right to their future. Whether or not people act on it, that's beyond me. But we need to tell the story. And if I went to the media, first of all, nobody will listen to me. I was 34 years old, a young lawyer who was just struggling with my family. The beauty about legal action in court, it puts the issue on the table of discussion. And one way or another, there will be a resolution. Sooner or later, 10 years, 20 years, there will be a resolution. When I got the decision in the lower court that I lost, not just lost, but they didn't want me to tell a story, I said, oh, that's not nice. So I filed a petition to the Supreme Court just on the simple issue that, do these kids have a right or none? If you say none, then it so happened that the case landed in a sympathetic court and landed on the table because they chose by raffle. It landed on a justice who is a serious gardener and a lover of nature. It took 22 years, an entire generation. The most significant accomplishment as far as that case is concerned is not that I was able to file the case or dream up the theory, But it was to be able to convince my wife to use my children as plaintiffs. Try doing that to your wife.
In the case of Oposov versus Factoran, it illustrates how legal cases in the Philippines can involve arguments based on both natural law principles such as the intergenerational responsibility to achieve a just and equitable outcome. It involved a group of minors, represented by their parents, who filed a class suits against the Secretary of DENR. The plaintiffs sought to stop the issuance of timber license agreements or TLAS for the cutting and harvesting of timber in various parts of the Philippines. So what then is the natural law argument in here? So the plaintiffs argue that the government issues of TLAs and its failure to protect and preserve the environment violated the natural principle of intergenerational responsibility. They claim that the present generation had a moral obligation to protect and preserve the environment for the benefit of future generations, which is fundamental principle of natural law.
The plaintiffs also relied on positive law principles, such as the Philippine Constitution, which mandates the protection of the environment. Specifically, they cited Article 2, Section 16, which declares that the state shall protect and advance the right of the people to a balanced and healthful ecology. The Supreme Court of the Philippines, in its decision, acknowledged the relevance of both natural law and positive law in the case. The court ruled in favor of the plaintiffs, stating that the right to a balanced and healthful ecology is a fundamental right that the government must protect and uphold. It is recognized the intergenerational responsibility to protect the environment as a matter of natural law and held that the government's issuance of TLAs without due regard for the environment violated positive law. So this case illustrates how legal cases in the Philippines can involve arguments based on both natural law principles such as intergenerational responsibility and positive law such as constitutional provisions in order to achieve a just and equitable outcome in the cases. While the previous case illustrates how legal cases in the Philippines can involve arguments based on both natural law and positive law, this case demonstrates a conflict.
Pag natapos na itong problema natin, itong February 5, sa madilim na lugar, February 6 siguro, magiging maganda ng takbo ng buhay natin. Diyan siguro magsisimula yung maganda nating buhay.
This case involved Leo Echegaray, who was convicted of raping his 10-year-old stepdaughter. He was sentenced to death by lethal injection under Republic Act No. 7659, which provided for the imposition of the death penalty for certain heinous crimes. Echegaray's defense, as well as various human rights groups, invoked natural law principles. They argued that the imposition of the death penalty in this case violated the national law principles of inherent human dignity and the right to life. They contended that the death penalty constitutes cruel, inhuman, and degrading punishment, contrary to the natural law principles that underpin fundamental human rights. For positive law argument, the government, particularly the prosecution, relied on positive law. specifically Republic Act number 7659, which mandated the death penalty for certain serious offenses. They argued that the law had been duly enacted by the legislature and should be upheld by the courts as the positive law of the land. The Supreme Court of the Philippines, after considering both the natural law and positive law arguments, ruled to affirm Echegaray's death sentence. The court recognized the tension between the moral principles of natural law, particularly the right to life, and positive law implemented by the legislation permitting the death penalty. The court emphasized that while there might be moral reservations regarding the death penalty, it was within the prerogative of the legislature to enact such laws, and the courts must uphold the legality of these statutes. So, in this case, it clearly demonstrates the conflict between natural law principles, such as the right to life and human dignity, and positive law, specifically a law allowing the imposition of the death penalty for certain crimes. Ultimately, in this instance, the court upheld the positive law, acknowledging the legislative authority to establish penalties for certain offenses, despite the moral and ethical arguments grounded in natural law principles.